justice anywhere is a threat to justice everywhere.
We won't relent. We will fight until the end. We have been sent to protect and to defend.
We won't relent. We will fight until the end.
We have been sent
to protect and to defend. Let justice flow like a river, flow from the peaks to the ground. Let justice flow like a river,
till only freedom is found. We count the cost.
we will pledge our very lives. All nation lost, but the kingdom will arise. Let justice flow like a river, flow from the peaks to the ground. Let justice flow like a river, till only freedom is found. Let justice flow like a river, flow from the peaks to the ground. Let justice flow like a river, till only freedom is found. The coastlines will know. The coastlines will know. The coastlines will know your justice.
The islands will know. The islands will know.
The islands will know your justice. The nations will know. The nations will know. The nations will know your justice. The coastlands will.
Okay, good evening. Good evening, everyone, wherever you're watching me from. Good evening to you. Please share the live stream. Let us get learning. Welcome to the legal literacy program or project in which my team and I will try by all means to ensure that legal education, or at least legal literacy in itself, is advanced, and we advocate for more and more literacy. So in today's session of the second edition of this project, we'll be talking about the Zambian Constitution. Lesson 2 will focus on the Zambian Constitution, and I'll try as much as possible to add a voice to various issues that are revolving around this topic or subject of discussion. So just give me a minute. Okay, so let us get into the lesson. Now, a constitution is one of the most fundamental documents or most fundamental laws that any country has. Especially for constitutional republics like Zambia, the constitution plays a very pivotal role in directing the people themselves, in directing the government and so many other stakeholders on what exactly is involved in the interactions that exist between the people and the government itself. I'll go in depth in trying to elaborate on what it really means when we're talking about the constitution and what are some of the legally recognized manner or ways in which the constitution is defined and explained. I'll go in depth in just a matter of seconds. So Zambia as a landlocked country in the sub-Saharan Africa is one that is built on rich history. Our history is very rich, and if you took time to really go in depth into uncovering some of the things that have happened in the past and that has shaped our legal system, that has shaped our identity, you'd really easily fall in love with being a Zambian. But that is not the lesson for today. Today is not Pan-Africanism. Today we focus solely on the Zambian constitution. Now, what does it mean when we say a constitution? The simplest definition that exists is that it is basically, a set of rules that establishes the government, confers upon them powers, and creates key institutions that help in governance or that exercise governmental power. Of course, governmental power is divided into three. We've got the legislature, we've got the executive, and we've got the judiciary, exercising the three kinds of powers that exist generally. So this is where the power is actually created from. The constitution establishes key institutions in a country. It establishes what we're referring to as a government, and creates with it not just the government itself, but confers upon each and every aspect of government their requisite authorities or powers that they can exercise, and thus creating some form of regulation that guides on how a government conducts itself, that guides on how these key institutions operate. So all these things that I've referred to are part and parcel of what is called a constitution. Of course, there are different types of constitutions, which I will not go in depth in explaining, but maybe just to mention a couple of these. We have a written constitution, we have an unwritten constitution, there's a rigid constitution, a presidential constitution, and so many other types of constitutions that you'd come across. But to put it plainly, our constitution is written. Our constitution is written. So we have a written constitution, and because it is written, we can find and derive some of these rules and some of these powers and these offices that are created from this same constitution. And for those who don't know, the constitution is available for all. It is a piece of document that is created for you and me. It is a piece of document that is not only created for the government of the day, but it is created for you and me as citizens of this particular beautiful country. This is why you'd find that even the introductory segment or part of the constitution, it says it is a constitution that is made for the people of Zambia, and you and me are the people of Zambia. So it is a document that guides us on matters of governance. So it creates these governmental institutions. It creates the government itself. So if you want to learn about these institutions and where they really derive their existence from, pick up a constitution, read through and see the various parts of it. One of the things that have really killed us as a generation or as a country, insofar as legislation is concerned, especially with regards to the constitution, is that we don't know the content of the document. We don't know what is there. So we need to pick it up. You and I, we need to pick that document up and really go in depth in trying to understand and, trying to dissect this document, so that in the near future, as leaders of this country, as leaders of future leaders and the leaders of today for this country, we're able to, articulate ourselves properly when it comes to matters of the constitution, and not only, getting excited about a particular case that I will not mention. Okay, so from there, we can also say that it is the supreme law of the land. So our constitution, when you go to Article 1, Clause 1, by the way, when we're citing the constitution, we use the terms article and clause. It's an article and clause. So there's Article 1 and there's Clause 1. So when you open the constitution, the very first article and its sub paragraph. That is Article 1, Clause 1. So it says that it is the supreme law of the land. And it explains what it means when it says it is supreme. It is the law that is above all laws. That's the constitution. It is a law that is above all laws. So any other law that is created in Zambia, any other law that is applied in Zambia, any other law that is of relevance to Zambia should be in line with the constitution. Thus, it retains its supremacy at the helm of authority, at the helm of the hierarchy of all the laws that are in operation here in Zambia. So it is the supreme law of the land. And I've cited a very good example. For law students, you will find this case in your studies, and it will come up and again and again, and until maybe you finish your degree or diploma or certificate program. It's a very famous case, and it is Christine Mulundika and 7 others versus the people, where we see an exemplification or an example of this supremacy that we're talking about really being brought to life. So if the powers of the powers that are conferred upon the officers, that is the police themselves, in the exercise of these powers, they go beyond the powers, or they in some way or the other, like what happened in this case, restrict your enjoyment of human rights, that is a violation of the constitution. That is a contradiction to what is provided for in the constitution. And because of it, that particular law is supposed to be subjected to the constitution. It is supposed to be declared redundant. And that is exactly what happened in this case. The requirement of a permit from the police is in fact contrary to the constitution of Zambia. You can't be required to get a permit for you to hold a public lorry or whatever it is. It is not a permit anymore. For now, maybe it is because of use of terms that a lot of us still use the term permit. But it is basically the procedure that is created now is that you basically notifying the police that you'll be holding, a public lorry, or you'll be holding an event, and they'll be able to come in and provide the necessary security and check if there's any requirement for police officers to be on the scene, or if the matter is is going to be carried out peacefully, and so on and so forth. So these procedures are provided for. The Public Order Act, which was a statute that was being considered in this case, provides for this. It provides that the police have got the power to ensure that there's public order and peace. But at the end of the day, in the exercise of their authority, there's need for them to exercise it properly and in accordance with the constitution. So if they act contrary to that, if they act contrary to what is prescribed in the constitution, it is going to be declared as redundant, or it is going to be declared as inconsistency, and that provision will cease to have its effect in law. So it is the supreme law of the land, and I can cite so many other examples. If you listened to our first lecture, I talked about Kaniki versus Jairus, a very interesting case as well. There are so many cases that speaks to the supremacy of the constitution. So just as an example, I'll end at Christine Mulundika and 7 others, and I won't go in depth in commenting about the case. But let us proceed to the third definition. So the constitution is also called a grand norm. So these are theories that are behind laws. So when you say it is a grand norm, it basically means supremacy as well, but in another way. It sets up the legal framework itself. It is the foundation upon which any legal system is created, and thus it is grand. If the constitution change, it means that there has been a shift in the grand norm. If, for example, there has been a revolution in the country, and the current government, as a matter of maybe commentary, the current government is changed through unlawful means like coups, there will be a need for the creation of a new constitution, because that constitution that was providing for, a peaceful change has been violated to an extent that there's need for the legal system to change. So it is the grand norm. It sets the tone. It is the foundation upon which every legal, every legal system is built. So it is called a grand norm, and we can end there for the grand norm theory. Then there is what is known as the social contract theory. So the constitution is also called a social contract. Now, the reason for this is because the constitution does not only provide for the powers of government, it also provides for, the benefits, the rights, the entitlements, the claims that are for the people. So it creates a contract between the government and the governed being you and I, and the government being the key institutions. This creates a sort of a symbiotic relationship between the government and the governed. That is, as we're giving up our powers to, freely roam the streets, freely, do whatever we want, laissez-faire kind of system. We are giving up that particular, privilege to be governed by a set of rules. But this privilege is not just being given. We're giving up that privilege for us to retain something in return. For example, you've got, as a Zambian, or as a person who's been resident here in Zambia, you've got a right to go and get your national registration card. You've got the right to be protected by this particular country, and you've got the right to claim for things that are not being provided for you. For example, if there's no medicine in the hospital, you've got the right to complain and claim, because it is that which you are getting as a result of giving up that freedom that we're referring to. We're giving the government the powers to regulate us, but in exchange, we're expecting that they provide something for us. So, for example, public roads, or as they are called, public goods. So they build hospitals, they build schools, they provide for policies that allow us to, live a very, very peaceful life. So all this is being given to you because you've entered into a contract with the government. So this is what is being called the social contract theory. So the constitution in itself is also a contract. It's a contract between you and the government. Okay, so those are the definitions. The reason as to why I've gone in depth in, explaining the definitions of the constitution. There are several of them, but these are the key four that I picked. It's very, very important that we understand what we're talking about. It's very, very important. If you say, we were learning about the constitution today, you should be able to explain yourself. Why the constitution? Why the constitution? Why is it that this document, has been a subject of discussion on several platforms? You need to be able to, articulate yourself to that extent. So it is a contract. It is a grand norm. It is supreme. It sets the tone for our legal system. It's very, very, very important. Now, we move. Zambia, despite its rich history, has been battling, if I can put it in that way, battling with having a constitution that stands, or that has stood the test of time, like the American Constitution. It has battled with this deficit for a very long time. And for us to really appreciate, this rich history, we need to look at several things that happened, prior to us having a constitution, and maybe we can understand some of the characteristics or some of the features that we've seen from a distance are evident in our constitution or in the practices. For example, judges wearing those wigs and lawyers wearing the wigs as well, and the traditional outfits. Maybe we can understand them when we understand the history. Though we'll not go in depth in that. I'm just, trying to give you an example. Now we're focusing on the constitution. So what are some of the historical landmarks that has happened in relation to the constitution or close to the constitution? So before colonialism, the term constitution was unheard of. And this is very simple. It's because at the time, each region or each part of what we call Zambia today was being regulated by a particular by a particular culture, by a particular traditional leader, and they weren't really united per se. It was just different settlements being regulated by various traditional leaders and so on and so forth. So at that point, really, the constitution was nowhere to be seen. But officially, in the 1950s, the constitution started rising from there. And before this, we know that there was the rule of the British South African Company, the BSSC. For those who've done history or those who've done civic education, you'd relate to this. But there was a company called BSC, British South African Company, BSCCA. So it's the British South African Company came in to regulate with the authorization of the Crown from England. They came in to regulate, but before them, after them, there was an administration that was sent to take over what we at the time what was Northern Rhodesia or present day Zambia. So Northern Rhodesia was now put under the direct control of the British administration, and we see the constitutional foundation being created. And of course, there was no document at that time, and this is because in England there is an unwritten constitution. So even at the time when they were coming to rule Zambia, when they were taken over, they basically used what we call common law. So there wasn't really a written constitution, because the constitution is unwritten, and they believe in legislative supremacy, something that I'll talk about maybe as we do these lectures. So in 1950, in the early 1950s, we see the British administration claiming control over Rhodesia and Nyasaland. So the Rhodesia and Nyasaland that we're referring to here is both southern Rhodesia, northern Rhodesia, and Nyasaland, which are presently called Malawi, Zambia, and Zimbabwe. So this territory was now under the direct control of the British administration, and this is where we saw the creation of a federation between the three regions. So there was a federation that was created by an order in council in 1953. So at that time, these regions were undivided. And then, due to several reasons and several factors, history is told in so many ways, but due to several factors, in the 1960s, after a series of strikes, a civil conflict between the natives and the white settlers, there was a disbanding of this federation in the early 1960s. And in 1962, an order in council was passed, which set the foundation for the maiden constitution of Northern Rhodesia. Now, as they were in this transitional period, there were several things that happened, and in relation to the constitution, there were negotiations that were being made between the white settlers and the native Africans. But at the same time, there were negotiations that were being made between the native Africans themselves. So if you go to the map or you search through history, you'd find that Northern Rhodesia was next to a piece of land called Balosa land, which was under the control of the Litunga. So there was Northern Rhodesia, and then there was Balosa land, and then there were these other protectorates. So Balosa land was not under the control of the white settlers, but it was affected by these relations that were created, or this environment that was created by the white settlers at the time. And after this transitional period was effected in 1962 going forward, the British administration lost control of Northern Rhodesia, and President before then, Prime Minister Kenneth Kaunda took over as a key stakeholder in representing the African settlers in this portion of land we call Zambia today. Before it was called Northern Rhodesia. Yeah. So Kenneth Kaunda was not only having negotiations with the white settlers, he started having negotiations with the Lutunga as well. And this is where we see, the agreement that has been in a lot of conversations, especially in relation to the Zambian history. The Balosa Land Agreement came to life in the transitional period before we even became Zambia. Was still Northern Rhodesia at the time. So Northern Rhodesia and Balosa Land entered into a contract, which is called the Balosa Land Agreement, which formed, or as a result of which, there was a formation of a unitary state, which we now call Zambia. On May 18, 1964, the Balosa Land Agreement came to life and effect, killing or having the effect of killing Northern Rhodesia and Balosa Land and forming one unit, which we now call Zambia. On October 24th, 1964, the Independence Order in Council came into operation, which gave now total control back to the African settlers of this portion that we call Zambia, and that came with the constitution, the Independent Constitution of Zambia, 1964, which guided on how matters were going to be administered from then going forward as far as Zambia is concerned. So this background that I've just tried to explain to you is very, very important in understanding the transitional periods that we've encountered as far as the constitution is concerned. We have transitioned from Northern Rhodesia to Federation and to now Zambia. These changes were just not historical events. They were indicative of a move to what we now respect and hold so sacred, the Constitution of Zambia. Now, from the time of colonization to 1964, Zambia is born. Zambia is born and is free. The people are allowed to, enjoy all the privileges that we enjoy now. And this is because we're now independent from British administration. Zambia was one of the first countries to ever, gain independence from British control. And in the sub-Saharan Africa, it was actually the first republic. In 1964, the constitution, which came with the Order in Council, created a multi-party system. That is, now people were allowed to form political parties and participate in elections. But at the time, the late President Kenneth Kaunda and his party, the United Nations Independence Party, or UNIP, which had a lot of influence, took over or won the elections and actually became the very first administration that Zambia had under the leadership of the now President Kenneth Kaunda, as he was formerly Prime Minister in transition. So these are key information. This is key data that you need to take into consideration. Now, in Zambia, we have adopted the CRC mode of reviewing our constitution and advising on the various changes that could be made. But there are certain phases that our constitution has gone through, which has given it its status today. In 1964, the Independence Constitution established, a post-colonial government. It facilitated Zambia's independence and, established the governance system or structure after independence. It talked to and emphasized on independence and established basic rights, but there were some limitations on these rights that came with the Constitution. One such right is interference with a person's land. Before the current right that we have in the Constitution, which under which one can be subjected to what is called the mandatory acquisition of land by the government, there wasn't really that freedom that was there in the Independence Constitution. So as the drafters of the first constitution was drafting it, they intended to ensure that that land that belonged to the white settlers could just remain just like that. But this developed or created a lot of problems for the Kaunda administration. And if you follow through history, specifically under land law, you would find that there were various portions of land that were left and not to be interfered with by absentee landlords. And this was a problem that was in fact affecting proper administration, because there wasn't really a lot of land that was left, and even that land that was beneficial was protected by these constitutional basic rights. So there were those limitations that eventually were brought down and changed and altered and so on and so forth. So after 1964, the next phase that we see of the Zambian constitution changing is in 1973. In 1973, Dr. Kenneth Kaunda and his theory of humanism, moved the CRC under the guidance of Professor Chona, which is called after him the Chona Constitutional Review Commission, which brought in one-partism. So the theory of multi-partism was thrown out of the window, and one-partism came to the fore. So that is, Zambia became a one-party state, and only UNIP was the party that was allowed to exist at the time. And the entire administration was run by the United Nations Independence Party, and making the president Kenneth Kaunda the one key political player at the time. And there were several other things that happened. In 1973, from 1973 to 1991, there were some challenges that were made, and the movement for multi-party democracy, MMD, played a very pivotal role in influencing the third phase of change. And in 1991, the president, Kenneth Kaunda, instructed a constitutional review commission, which looked into reviewing the constitution. The 1991 Constitutional Review Commission brought back multi-partism, and the constitution that was created, facilitated for the appreciation of democratic principles and individual rights. So the Bill of Rights that we have now was now introduced in 1991. So the 1991 Constitution, you'll find the Bill of Rights there. In 1996, the Bill of Rights was not changed, but other parts of the Constitution were changed, and this process was led by President Chiluba in the 1996 Constitutional Amendment. President Levi Patrick Manawasa, may his soul rest in peace, in 2003 initiated the fifth phase the Mungomba Constitutional Review Commission was created to facilitate for this purpose. But unfortunately, that particular Constitutional Review Commission ultimately stalled. It did not come into fruition. It didn't bring a lot of changes. And even, the 14 steps plan that President Mwanawasa created at the time was refused by the Zambian people, because he brought in a plan of, changing the constitution and changing various things about it. For example, the adoption process itself, subjecting the constitutional review process to what was called the National Constitutional Conference, NCC. And the bill was actually created to facilitate for the creation of this body, which will, go into reviewing the constitution and then subjecting, if they have touched on the Bill of Rights, some of the amendments to a referendum and others, back to Parliament. So entirely removing the review process, entirely removing the CRC at the time. So all those things did not come to fruition. There was political influence, and even his plan was for us to review the constitution in a period of 5 years. So a lot of people were really not for the idea. It raised a lot of eyebrows. So that process failed. The next phase that we saw was in 2016, where President Michael Chilifesata appointed Justice Ano Silungwe, State Counsel, Honorable Justice Silungwe, State Counsel, who led that particular Constitutional Review Commission, and they came up with what we are currently using, the Constitutional Amendment number 2 of 2016. And this is a very, very important, a very important piece of legislation. And one more thing, as a by the way statement, I've seen a lot of people say we have two constitutions in Zambia, which I really differ with. We have one constitution and several amendments. So the 1996 constitutional amendment, the only part that is relevant from that constitution is a Bill of Rights. So we don't have two constitutions, but we have two amendments that are currently, being applied. But we have one constitution. So in 2016, several parts of the constitution remained changed, rather, and the Bill of Rights remained unchanged due to several reasons, of course, one of which was, education was not much. There was a lot of political influence and so many other things that you can find online, and analysis have been made and information is available there. In 2019, former President Edgar Lungu established a CRC, which was led by Mr. Raphael Nakachinda, and this gentleman was rather an MP. I'm not sure if he still is an MP. Pardon my lack of knowledge in that area, but yeah, Raphael Nakachinda, who was an MP at the time, led the Constitutional Review Commission, and they brought about the infamous Bill 10, which was made a subject of many discussions. So all these phases that you've noted me talk about shows the various changes and attempts that have been made to perfect our constitution, to make it whole, to make it work and all that. But at the end of the day, all these phases have not brought about a constitution that is comprehensive enough. And there are so many challenges that have been noticed as a result of this. So the constitutional review processes that have been done so far has not given Zambia a long-lasting constitution. And even now, we hear the president talking about constitutional review, and the need for us to amend our constitution. And I'm saddened that it's going to be a process that is going to be done over and over and over again. Of course, there are various reasons of which I cannot speak to at the moment, but I'm sure you do have some reasons that you've noted on your own or on your part that has played a major role in influencing the leaders' decisions when it comes to constitutional review processes and the adoption of the constitution itself. There are several several reasons that have been released and that are already in the air as far as this subject is concerned. And you see and note that most of these amendments are done, to favor the sitting administration. And this is not something that is just mere speculation. It has been done, and this is recorded. It has been recorded. Even when the Constitutional Review Commission in 2003 was being created, it was just to serve one part of the nation, and not everybody. That administration alone. Even Bill 10, it was rebuked because a lot of powers were, again, being vested in the president, and all that is really influenced by our lack of knowledge. And this is really, really important. We need to understand the repercussions of us bringing to life a particular constitution with defects. If we confer powers on a particular office, what does it mean for us? What does it mean for us, and what does it mean for them? What does it mean for our democracy, and all those factors? And then the Constitutional Review Commission process is so biased in one way or the other, because when the Constitutional Review Commission makes that review of the current constitution and creates a draft or recommends changes, before it goes to Parliament, it has to go back to the president, who establishes the commission, and the president will select what to allow to go through and what not to allow. So you see, it is still being controlled by the executive wing of the government. And because of this, it lacks legitimacy. So on the challenges and limitations that we currently are facing for our constitution, you need to talk about things such as, lack of public support, political instability, lack of public support, the lack of proper representation. If you go to the constitution that we have right now, there's a requirement that, as far as representation is concerned, women should have 1/3, youth should have 1/3. The people living with disabilities should have representation in Parliament. But if you look at Parliament today, are those numbers or those factors speaking to being really upheld? Of course not. So there are several things that we need to really focus on and bring to life as far as our democracy is concerned. And the Constitution is very powerful too. It's a very powerful tool that we can really use, to bring all these factors to life. Some of the challenges and limitations, I've already mentioned them. Others are inadequate and incomplete Bill of Rights. Our Bill of Rights is particularly focused on just civil and political rights. There are no economical rights. There are no cultural rights. There are no social rights. They're just civil and political rights, which makes it very difficult because you need both of these types of rights as well as solidarity rights to be included in the Constitution in order for you to have, a complete bill of rights. Kenya, the Republic of Kenya, the Republic of South Africa, they have complete rights. And all these rights, of course, this is not everything, but all the major characteristics and types of rights are included in their constitution. You find a section for women's rights. You find a section for people living with disabilities. You find a section for environmental rights. In their constitution, it is there. But in our constitution, those types of rights, which are called claim rights, are merely reflected in the directive principles of state practices. And now, Article 8 and 9 of the Constitution, speaking to those rights in one way or the other. That is not how it's supposed to be. The Bill of Rights should have those rights available there. And the reason as to why I'm emphasizing this is because in order for you to claim in the courts that we don't have, hospitals, the Ministry of Health needs to do something about it. There's no medicine in the hospitals. You need to have a right to do so. But then for you to do it, you have to take a very, very long route in order for you to go to the court and claim that your rights are being violated, and you need vindication. Because now you need to, cite that your civil rights are being violated. Like what happened in the Mwanza and Beni versus the Attorney General case, a case that has been talked about as being academic in one way or the other. But yeah, people living with HIV and AIDS are in prison. They're not being given proper food. They're not being given the right medication. They're given expired medication according to those claims, rotten beans and everything else. The only way they will enforce their health rights if they say, because we don't have health, our the right to life is violated. And we can't always be, playing the hitherto or neither to or there card every time. We need to have those rights included. And there was an attempt actually in 2016 to include these rights, but unfortunately, because of political influence and so many other factors, that couldn't happen. So maybe in the constitutional review commission that is going to be established in the near future, we can see these rights being given or these rights being provided for without closed and back doors. Maybe that is going to happen. Then there's also political influence, which is attributable to the broad powers that are conferred on the executive, specifically on the president. There are so many powers that this office has, and we need to dilute them. And there's the method of changing, adopting, and creating the constitution has been criticized as well, because it is not inclusive. And this is where you find that there are recommendations for bringing on board a constituent assembly, and not just having parliament debate on these matters, because it is underrepresented. So those are some of the challenges and the limitations that are there insofar as the constitution is concerned. Now, I want to draw attention to some of the things that have happened as far as the constitution is concerned, specifically when it comes to the 2016 constitution. So what are some of the things that were brought in that constitution that you need to be aware of? So there was the court system itself. It was changed a bit. The High Court was conferred with unlimited jurisdiction. Of course, it was the supervision that was there, but it was furthermore talked about. You have the Constitutional Court now, as some of the major changes that have been incorporated in the Constitution. The Constitutional Court, which hears all matters relating to the Constitution, and it provides for several remedies insofar as the Constitution is concerned. And one of the most common ones is the recently decided eligibility case, which is one of the cases that they have worked on, applying constitutional principles and so on and so forth. But there's still need for us to work on our constitution. There's so much that we can do as far as the constitution is concerned. The Bill of Rights in itself needs to be worked on. The powers that are being conferred on these offices, they need to be worked on, and so many others. These challenges are not sitting here, or limitations are not sitting here for us to just point to them every now and then, that these are the challenges, these are the limitations. We need to now, armed with knowledge, we need to work on how we're going to really address these problems now. So that is what I prepared for you as far as the Zambian constitution is concerned. You can find yourself a couple of constitutions, try to dig in, read, and understand what we're talking about when we're talking about the Constitution of Zambia. It's a very, very interesting and very important document that you cannot go without. And with those few remarks, I would like to thank you. Thank you for making the time to attend this session. It's a very, very important session, by the way. I must emphasize, it's a very, very important session. We need to be having these important conversations that build our nation and make us who we are as far as our identity is concerned. It's very, very important that we continue having these discussions, these talks, so that we are aware of our rights, we're aware of the law that is regulating us, and we can make informed decisions insofar as our rights are concerned. And when we are approaching, the change of leadership through voting, we are able to do so armed with information. We're able to analyze what these politicians are saying. Political rhetoric can be used to our disadvantage. So we need to be woke about the constitution, so that whenever there's need for maybe your participation through a referendum, you'll be able to really understand that this is what is really the motive behind the drive to change the constitution. So that is our lesson for the day. I'll see you once more next week for another very interesting segment of the Legal Literacy Project. Thank you so much, and have a lovely remainder of the day. Thank you.
We will fight until the end.
We have been sent
to protect